Back to the action. Now focusing on question 7. Take a look at the call of the question here. In a suit by the landowner against the bus driver for damages to her zinnias, A, the bus driver is liable for trespass because his driving caused the pedestrian to enter the landowner's yard. Okay, that's an incorrect answer for sure, because trespassing is an intentional tort. And if the bus driver did something to cause someone else to enter the land, the bus driver would be liable for negligence, not for the intentional tort of trespass. B, bus driver liable on the theory of negligence. Potentially correct. C, bus driver not liable because the landowner's zinnias were not within the scope of any duty he owed in operating a bus on a public road. Kind of doubt it, but possible. We'll look at the facts. D, if the bus driver is held liable on any theory, he is entitled to indemnity from the pedestrian who did the damage. Not a great pick, but not facially wrong. Look at the fact pattern. A pedestrian walking along an unpaved road on his way to work saw a school bus coming in the opposite direction, suddenly begin to careen toward him. The bus driver had momentarily lost control while attempting to light a cigarette. Okay, that's an act of negligence. If there's a big accident, maybe recklessness. But that's what the bus driver's done. To avoid being hit by the bus, the pedestrian jumped off the road, landed in prize-winning zinnias, damaged the flowers. Okay, now look at the call of the question again. Landowner suing bus driver for damages, as opposed to saying for negligence, for trespass, etc. She's suing for damages. Pick A, bus driver liable for trespass because his driving caused the pedestrian. Okay, that's still wrong. B, bus driver liable on a theory of negligence. The loud bell rings. That looks like the right answer, and it will prove to be so. C, bus driver not liable because the landowner's zinnias were not within the scope of duty. Yeah, they were, because the damage to the zinnias is foreseeable based on his losing control of the bus temporarily. It's totally foreseeable a pedestrian would jump off the street if he or she was afraid of getting hit. And then D, if the bus driver is held liable, he's entitled to indemnity. No, he's not, because the pedestrian didn't do anything wrong. Yeah, the pedestrian did cause the damage, but here again, the pedestrian's entry is privileged based on private necessity to avoid getting run over by a bus. Pedestrian is potentially liable for the value of the zinnias, but would be entitled to full indemnity from the bus company because they're the ones who are really legally the cause of what happened. That is a pretty good question too, and not atypical. So the correct answer is B. Yes, the bus driver is liable on a theory of negligence. And we turn next to question 8. Look at the call of the question. I think this is the hardest question in the first. This may be the hardest question of the whole pack. It's a very technical torts question about landowner liability. Call of the question. In a suit by the boy against the neighbor for these injuries, whatever they are. A, the neighbor is liable because the boy entered with her permission. Okay, a permissive entry would make that boy, what, a licensee, an invitee? Because the boy would be, well, let's go on, let's move on a little bit and look at the actual, a licensee is coming on to help the person who owns the property. Let's read on. You're on the right track. B, the neighbor is liable because she failed to repair a dangerous condition on her property. Okay, well, we know landowners sometimes have that duty, but the question is, does this landowner have it here? We don't know yet because we've got to look at the facts. C, the neighbor is liable because she failed to reasonably inspect the property, which would have made her aware of the dangerous condition of the wire. Okay, a duty to inspect, again, depends on how we characterize the person who's on the property. And then D, the neighbor is not liable because she did not know of the condition of the wire. Now, it's going to turn out that D is the correct answer to this question. And it is a very technical result. and I'm going to refer to slightly more elaborate notes than I have for the earlier ones to make sure that I'm a little more precise about this. Okay, here's the reason why D is the correct answer. I'll go through the others in a moment and take your questions. The correct answer to question 8 is D. The neighbor is not liable because she did not know of the condition of the wire and the boy was a licensee. The boy has entered the property with the owner's permission for the purpose of retrieving that ball, as opposed to the purpose of delivering a pizza or something along those lines. Okay, now, this is the question that you're likely to get wrong because you're not razor sharp on landowner liability. Okay, well, welcome to the party. This is how it's tested. This is as hard a question as they can give you because you've really got to know the law in order to get it right. But once we establish the landowner's duty to this boy based on his status as a licensee, the right answer jumps off the page. So we go to the top of the question, look at it very briefly. Boy's playing softball in a park, ball hit over the fence into the neighbor's yard, asks for permission, the neighbor says yeah. Okay, what's the neighbor's duty at this point? To warn of known hazards. No duty to inspect, no duty that the property be safe. All right? So, pick A. The neighbor is liable because the boy entered with her permission. Wrong. But in fact, we start from the result. Before we look at the picks, in a suit by the boy against the neighbor for these injuries, who wins? The boy loses. And the reason the boy loses is because the landowner had no duty to inspect and couldn't warn of a fault that the owner was unaware of. So A is wrong because it mischaracterizes the consequence of the facts. B, the neighbor is liable because she failed to repair. That's wrong because she had no duty to repair. C, the neighbor is liable because she failed to reasonably inspect. Also wrong. That wasn't part of her duty. So D becomes the correct answer pick through a process of elimination, really. This is a hard question because you have to read it very carefully and you have to know the law very well in order to get it correct. So, but notice how this is the 8th question we've done, and the other 7 did not require this kind of fine line knowledge. And incidentally, to get this right in 1.8 minutes is further challenging because you don't really have a lot of time to reflect on it. Go to question 9. If the pedestrian sues the mapping service for invasion of privacy, how should the court rule? Okay. Fairly hard to pick based on these choices, but let's have a look. Pedestrian versus mapping service for invasion of privacy. A, for the mapping service because the disclosure was of someone in a public place. Potentially correct. B, for the mapping service unless the pedestrian's employer canceled his health insurance discount. Okay, a damages question based on invasion of privacy, dubious. C, for the pedestrian because there was widespread public disclosure by the mapping service of a private fact. Okay, that is a quasi-intentional tort. We'll have to read the facts again. D, for the pedestrian because he was on the premises of a business rather than a public sidewalk when the image was taken. Okay, let's look at the facts. A mapping service on the internet that provides maps and satellite images of urban areas developed a tourist view option that offered street-level views of many downtown locations. In one street view image, a pedestrian could be seen on the steps outside of a business while smoking a cigarette. Okay, so he's on the steps of a business smoking. Supervisor recognizes him and was surprised to see him smoking because he had this discount. Okay, how should the court rule? A looks like a great pick. For the mapping service because the disclosure was of someone in a public place. If he'd been doing something privately and they snooped him out and published that, potential liability. But A looks like a good pick. Let's look at the others. For the mapping service unless the pedestrian's employer canceled his health insurance. Well, you know what? He could lose his health insurance and A would still be a better pick. The damages caused, that is not a necessary element of the theory of liability here. C, for the pedestrian, because there was widespread public disclosure of a private fact, if he wants his smoking to be private, he should not do it where he can be seen by cameras in public. D, for the pedestrian, because he was on the premises of a business rather than a public sidewalk. That's a closer call. If somehow he'd been photographed somewhere in the interior of the business environment, a somewhat closer call. But A is clearly the correct pick under the circumstances of this question. So I will conclude here, give you a chance to ask a question if any come to mind, and after this video, which I will stop in a moment, then you'll have a chance to answer the remaining questions in the packet. If you want to take a break too, you can, and we'll come back in 20 or maybe 25 minutes to factor in a little break time and go over the remaining questions.